Good afternoon, students. Today is Wednesday, 2 March 2022. This will be our second lecture of the week. Remember, I'm posting videos on Monday and Wednesday each week. On Tuesday and Thursday, I will be in the classroom, but that will be reserved for discussion, and it's entirely optional for you whether to come to that discussion session. I think we had only one student yesterday. And we spent an hour talking about various things, including the course material. Okay, just a reminder, I'll probably keep reminding you as we go. The second exam is on the 31st of March, so make sure you put that on your calendar. And once again, you will be going into Canvas at 8 o'clock in the morning on that day and taking your exam. It's 4 weeks from tomorrow, the 31st of March. There are a couple of new items posted. I have posted the article that we're starting today. It's an article by Bonnie Steinbock entitled Drunk Driving. In fact, you may have noticed when I held this up, I wrote here as a note to myself, this is a beautiful thesis defense essay. It really is beautifully crafted. Anybody who reads it will be impressed by not only the quality of Bonnie Steinbock's reasoning, but the quality of her writing. It's really a terrific essay. In fact, years ago, when I taught the department's research and writing course, I chose this and a couple of other essays as my models of a thesis defense paper. So when you read an article like this, you should try to emulate it. You should try to copy Steinbock. Not the substance, but the form. Try to write the way she does, very clearly, succinctly. You should never be in doubt when you read this essay about what she's talking about or what claims she is making. She's a terrific writer. Okay, so that's the article. It's posted now. By the time before you watch this video, in fact, if you turn this video on, by now you should have read at least part 1 of her article, which is entitled Malice and Murder. Okay, that should be enough for today. By next week, by the first video that I post next week, you probably should have read the whole article. Okay, you can read it in chunks. I recommend that you hold off on watching my videos until you've done the appropriate reading. And also, the second thing I posted yesterday is my lecture notes for this essay. I think they run 11 pages long. So we've got a lot of ground to cover, and I should shut up and get to it, and I will in just a moment. Now I have a few other items that I'll be posting along the way. At least one other item will be posted today. In fact, I would recommend that before you continue watching this video, not only should you have read the first part of Steinbock's essay, you should have looked over my lecture notes because you can then follow along as you watch my video. But you should also have in front of you one of the things that I'll be posting on Canvas today, and it's entitled A Taxonomy of Homicide. It's not yet posted, but when I go onto the computer later on to post this video on Canvas, I will at roughly the same time put up this taxonomy, and you can follow along on it as you go. In fact, I'll refer to it today as I go along. Okay, so that's what's posted. We're going to spend 3 days on this article. The 3 days are today and both days next week. And guess what's after that? Spring break. Our annual spring break will be the week following next week. And when we come back from spring break, we'll take up the next item. Okay, so that's what we're doing today, and that's what lies ahead of us. So let's get started. Again, I hope you have the lecture notes in front of you. You can follow along, maybe making notes in the margin as we go. I don't cover literally everything in my lecture notes during my recorded lectures, but I do cover most of it, as I'm sure you know by now. Okay, let's get started. I have broken my lecture notes down into various parts, and they correspond with Steinbock's sections, including her titles. but I've added a section called Introduction, and I labeled it 0 because she starts off with numeral 1. So here are some introductory remarks before we get to the real substance of her essay. First of all, what is Steinbock's conclusion? What is her grand claim in this essay? The title is simply Drunk Driving, so you don't know from the title alone what her take is or what her position is. Is she in favor of drunk driving? Is she against it? If she's against it, on what grounds is she against it? So here's what she says on page 278. She says, quote, I will defend the proposition that a significant class of drunk drivers who cause death does indeed commit and often get away with murder, unquote. Now that's a powerful claim, and I want to make sure you understand it. So I made a little diagram for you. If I were in the classroom, of course, I would write this on the board. So I'm going to hold it up as close as I can to the camera, and you can pause. Let me get my fingers out of there. You can pause the video and maybe write this diagram down in your own notes. You see it? So I'm going to pull back now and discuss this with you. Notice that there's a box, first of all. I made a box on this sticky sheet. And think of that box as containing all the people. It's a box of people. Anyone who's a person goes in the box. Anything in the world that's not a person, think of as being outside the box. Now, people are either drivers or they're not. The biggest circle in this diagram is the circle of drivers. And you can see that there's room outside the big circle within the people class. So that would be the area for people who are not drivers or who are not currently driving. Okay? So think of everyone who is currently driving as being in the big circle, the driver circle. Now within that circle, there are some drivers who drive drunk. We'll call them drunk drivers. Not everyone who drives a car is drunk, but some are. And so by drawing a smaller circle inside the big the big driver circle, I've shown that all drunk drivers are drivers, but not all drivers are drunk drivers. Now let's continue with this. You'll see a smaller circle inside the drunk driver circle. And these are drunk drivers who happen, while they're driving, to kill someone, or as Steinbock puts it, to cause the death of someone. So all drunk drivers who kill are drunk drivers, but not all drunk drivers are drunk drivers who kill. There are people, I'm sure, every day who are driving drunk, but who make it home safely without harming anyone, without killing anyone. We could say that they're lucky. They're lucky that they didn't encounter anybody on the roadway who was walking or riding a bike or maybe in another vehicle. So the small circle on this diagram is the set of drunk drivers who end up killing someone while they're driving drunk. And now let's read what Steinbock says in light of my diagram. She says, I will defend the proposition that a significant class of drunk drivers who cause death. Now, what circle is that? That's the smallest circle on here. She's saying that a significant class of people in that smallest circle commit murder. They do indeed commit, and even more tragically, sometimes get away with murder. So keep in mind that the class of people Steinbock is talking about is very small. She's not talking about all people. She's not saying all people are murderers, obviously. She's not saying that all drivers are murderers. She's not saying even that all drunk drivers are murderers. She's saying that some of the drunk drivers who kill are murderers. And even worse, they get away with murder. Literally, they get away with murder because they're not punished as the murderers that they are, in her view. Okay, so I'm still in the introductory part of my lecture notes. All I have to say beyond that is that Steinbock does a good job early on in her essay of mapping out the rest of her essay. And that's a good thing to do if you're writing a philosophical article. Let the reader know right off the bat what is to come. The reader may decide, once you describe where you're going, not to read any further. The reader may say, oh, I thought this was a descriptive account of drunk driving, but now I can see that it's an argumentative topic, and I'm not interested in that. So let's read a little bit of what she says on pages 278 and 279. Okay, she says, she repeats the sentence that I've already quoted, and then she says this. In section 1, and that's the one that starts on page 279, entitled Malice and Murder. In section 1, she says, I will examine the traditional reasons for regarding vehicular homicide as something less than murder, focusing on the concept of intent. I will argue that even though the drunk driver doesn't mean to kill anyone, doesn't intend to kill anyone, to engage in an activity as dangerous as driving while severely intoxicated is so risky as to evidence extreme indifference to the value of human life, and therefore may constitute the malice necessary for a second-degree murder conviction. Now, at this point, you may not know what second-degree murder is. If there's a second-degree murder, then presumably there's also a first-degree murder, and maybe even a third degree. But Steinbock is telling you in advance that while she thinks some drunk drivers who kill are murderers, she's also letting you know that they're only second-degree murderers, not first-degree murderers. Okay, here's what she says about section 2. In section 2, I will examine the argument that since drunk drivers who cause death are often alcoholics who cannot help drinking, it is unfair to hold them responsible and punish them for doing what they cannot control. Okay, that's the argument. Now here's what she says about it. Although I believe that this is a bad argument, I examine it in order to make explicit why it is fair to hold responsible for his actions an intoxicated person, as opposed, say, to an insane one. I will argue that while an alcoholic may not be responsible for his drinking, his decision to drink and drive in full knowledge of the risk he thereby poses to the safety of others is reckless. It is sometimes so reckless as to be the equivalent of intentional killing. In the last section, that would be section 3, I will turn from the notion of fair punishment to that of effective punishment and the question of deterrence. Arguments for stiffening penalties for drunk driving should not be based on deterrent efficacy, as the evidence for this is, at best, inconclusive. However, deterrence is not the only consideration. There's also justice. If at least some cases of causing death by drunk driving are cases of murder, and she argues that that is the case, sentences should be comparable to those given others convicted of murder. Slight or non-existent penalties for vehicular homicide allow people literally to get away with murder. And this is wrong, quite independently of whether stiffer penalties would reduce the number of highway fatalities. So there, in a pretty short amount of space, Steinbock tells you exactly what is contained in the rest of her article. Again, I believe this is a beautifully written and well-reasoned essay. Now, whether I agree with it or not is irrelevant. I'm expressing appreciation for the quality of her argumentation and the quality of her writing. And if you want to be a philosopher or write a philosophical essay, perhaps for a term paper for a course, this is the kind of paper that you should strive to emulate. All right, let's turn to the first main section of this article. It's entitled Malice and Murder. And again, you can follow along on my handout entitled A Taxonomy of Homicide. It's not yet posted, but by the time you watch this video, it will be. Okay, this first section of the article, as I say in my notes on page 1, is the argumentative section. This is the section where she makes an affirmative case for her conclusion that some drunk drivers who kill are murderers and should be punished as such. First, she begins with some facts, because some of her readers may not know the facts about drunk driving. You've heard of drunk driving, surely. You know what it is in a simple way, but maybe you don't know about the toll that is taken by drunk drivers in this country or elsewhere in the world. On page 279, she says the following: drunk driving, quote, contributes to approximately half of all highway deaths in the United States, killing about 25,000 people every year and injuring many more. Now, this essay was published in 1985, and that's, 37 years ago. It's conceivable that the statistics have changed somewhat. They may, if they have changed, they may have gotten worse. The toll taken by drunk driving may have gotten worse in the past 37 years. Maybe the toll is less now than it was then. I don't know. But at least at the time this article was written and published, these are the facts. 25,000 people every year killed by drunk drivers. I assume that includes the drunk drivers themselves who are killed. Okay, next fact, also on page 279. Even if he, referring to the drunk driver, injures or kills someone, plea bargaining and loopholes in the law make it unlikely that he will be convicted of a serious crime, and sentences tend to be light, unquote. So she's saying there, even those few drunk drivers who do get tried and convicted, they tend to get very light sentences. They're not punished like the murderers they are. And she thinks that's a problem. They should be punished as murderers, not as people who commit vehicular homicide or negligent homicide or something like that. And on page 285, she gives some startling statistics. The relative probability of a drinking driver's causing an accident is 45 times greater than that of a driver who has not been drinking if his blood alcohol level is 0.18%. So let's stop right there. If you compare people who drive with a blood alcohol content of 0.18% or higher with people who are driving without any alcohol content, they have not been drinking at all, the drunk drivers cause 45 times more accidents. That shows you the effect of extreme drinking or extreme inebriation or extreme intoxication. People lose the ability to control their vehicles when they're that intoxicated. Their reflexes are impaired. Their perceptual abilities are flawed. They're not able to see as easily. Their vision may be blurred as a result of their intoxication. So you're 45 times more likely to cause an accident if your blood alcohol content is 0.18% or higher, as you would be or as you are if you're driving unimpaired. Now let's reduce the 0.18 a little bit and see what happens. She says that the likelihood is 35 times greater if the level is 0.16%. So if you're not quite as intoxicated, you're not quite as likely, but still very likely to cause an accident. If your blood alcohol level goes down to 0.14%, you are 20 times more likely to cause an accident than if you were sober. And if your blood alcohol content is 0.10%, you are still 10 times more likely to cause an accident. So the statistics are very clear. Driving while drunk is dangerous. Driving itself is dangerous, of course, and she points that out in her article. But when you add drinking into the mix, the likelihood of causing accidents is staggering. Drunk drivers, she says at one point, in fact, it's right here in my notes, page 286. Drunk driving is inherently dangerous behavior. It's analogous to detonating a bomb in an empty building. So suppose you, just to see an explosion, you put a bomb in an empty building, or what you think is an empty building, and you detonate it. You may be sure or certain that there are no people in the building who can be injured by the blast, but you never know that for sure. If it's a large building with several floors, there may well be somebody in that building. Maybe a homeless person is sleeping in a room in the second floor. Unless you've checked literally every inch of the building, you don't know for sure that someone is not there. If you still go ahead and detonate a bomb, you are playing fast and loose with people's lives. That is extremely reckless. And it's like getting into a car when you're drunk. You may well make it home or make it where you're going without hitting anybody and without killing or injuring anybody. But you're playing with fire, to use a common metaphor. You are flirting with disaster. You're taking a grave risk with not only your own life, but the lives of other innocent people. So you could tell right off the bat that Steinbock has a certain animosity toward drunk driving, and maybe even to drunk drivers. She would say at a minimum that they're irresponsible. She would add, I think, that they're reckless, that they are depraved, especially if they do it regularly. If someone regularly gets drunk and then gets behind the wheel, even if that person always makes it home safely without injuring anyone, still that person is depraved. That person is putting bombs in empty buildings regularly. And it may turn out, luckily for that person, that no one is injured. But you don't know whether that will be the result when you put the bomb in the building and detonate it. Okay, so let's continue on page 1. Steinbock's claim is as follows. This is from page 278. Even though the drunk driver doesn't mean or intend to kill anyone, to engage in an activity as dangerous as driving while severely intoxicated is so risky as to evidence extreme indifference to the value of human life, and therefore may constitute the malice necessary for a second-degree murder conviction. Now, I realized when I started reading that I've already read that sentence when I went over her introduction. That's okay. It didn't take that long. Drunk driving, she says, is, quote, tantamount to the intentional infliction of harm comparable to shooting into a crowded room or setting a house on fire. Now, the words tantamount to mean equivalent in seriousness to, or virtually the same as. I'm sure you've heard that word. When she says that drunk driving is tantamount to the intentional infliction of harm, she's saying it's equivalent in seriousness to it, or virtually the same as. It's comparable to it. And then she adds, I submit, this is from a later page in her article, I submit that it's not the standard of one's driving while intoxicated that matters. It is the fact that one drove after drinking heavily when incapable of controlling a motor vehicle. Now, this is an important point, which is why I put it in my lecture notes. Steinbock is not claiming that the culpability of the driver, the blameworthiness of the driver, is bad driving. Right? I mean, you don't have to be drunk to drive badly. People get tickets for swerving and going off the road, or going too fast or too slow. People get tickets for that whether they've been drinking or not. That's just bad driving. So she's not claiming merely that drunk drivers are bad drivers. She's talking about their decision to get into the car and drive at all. That's where the recklessness lies. It's not in how adeptly they handle the steering wheel and keep the car in the proper lane and keep it on the road, that's part of it, yes. But she's also talking about the very decision to get into the car and drive at all. That's what's culpable. That's what's blameworthy. That's the crime, if you will. So let's try to figure out what her argument is. Sometimes when we're going over an article, I wait until the second or third class period to discuss the argument, but I'm going to discuss it now, early on, so that we can refer to it as we go along, if necessary. Okay, this is really not a single argument. It's what I've called before a chain argument. If you remember Stephen Wise's argument for abolition of factory farms, that was also a chain argument, a string of separate arguments that are linked together like a chain. So if you look for the word therefore in this argument, which goes from page 2 onto page 3 of my notes, you'll see the word therefore occurs 3 times. That means there are 3 separate arguments, and they are connected like a chain to one another. And the final or grand conclusion of this chain argument is proposition 8. And I used lowercase Roman numerals, 1 through 8, to refer to her premises and conclusions. So let's first of all go through and simply read the argument, and I'll make some comments on it. What kind of a claim is this, for example? And then we'll come back and look at the structure of her argument and why the conclusions really do follow from her premises. Okay, premise number 1, proposition number 1. It goes like this. If a person willfully acts in callous and wanton disregard of the consequences of the act to human life, he or she acts with malice aforethought. Now that's a term we haven't used yet, malice aforethought. You may have heard the term. We're going to talk more about it as we go. It's a term of art in the law. In fact, if you look on page 3, the footnote number 1, is a quotation from 2 law professors, and they talk about the meaning of the term malice aforethought. And they say there that the term does not at all have the ordinary meaning that you might think it has. And that's why I called it a term of art in the law. It's a term that is used by lawyers in a very special way. And it's not used in the ordinary way that an ordinary person would use it. So we'll look at that in a few minutes. But right now, all I'm saying is this. All Steinbock is saying is, if you willfully act in callous and wanton disregard of the consequences of the act to human life, you act with malice aforethought. Now, this is a legal definition. It's a sufficient condition for acting with malice aforethought that you willfully and wantonly disregard the consequences of your act. So you can think of this as either a legal definition, it's part of the definition of the term malice aforethought, or if you want, you can think of it as a conceptual claim. It's a claim about the meaning of the concept malice aforethought. It's not a factual claim. Steinbock is not describing how the world is in any way. It's not a moral judgment either. She's not making any moral claim about what's good or bad or right or wrong, fair or unfair, just or unjust, about what someone ought to do or shouldn't do or must do. All of those would be moral judgments. And you don't see any words like that in here. There's no ought or must or should or right or wrong or good or bad. So this, I suggest to you, is a conceptual claim. It's a claim about the concept of malice aforethought. And what it says is that if you act in callous and wanton disregard of the consequences of your act for human life, you have thereby acted with malice aforethought. That's part of the meaning of that term in the law. Let's move on to the second proposition. It's also a premise. This is a factual claim. She's making a claim about how the world is. She says some drunk drivers, and that makes it clear she's not talking about all of them, maybe not even most or many of them, but at least some, at least one. That would be the minimal interpretation, right? At least one. Let me get these things off the screen here. At least one drunk driver does willfully act in callous and wanton disregard of the consequences of the act to human life. Right? There's at least one person out there who acts in that way. Okay? Maybe many, but let's just interpret it in the most minimal way. At least one person falls into that category. That's a factual claim. Now, what do you get when you put 1 and 2 together? What conclusion can be drawn from those two premises? Well, it's proposition 3, and here's what it says. Some drunk drivers act with malice aforethought. That is also a factual claim. It's a claim about at least one drunk driver. And where did it come from? It came from the first two premises. The first premise tells you part of the meaning of malice aforethought, and the second premise says that there are in the world people who satisfy that requirement. So 3 says there's at least one drunk driver who acts with malice aforethought. All right, the argument does not stop there, because remember, Steinbock's conclusion is going to be a moral judgment. She's going to argue that certain drunk drivers should be punished as murderers because they commit murder in her view. So the argument needs to continue. We're partway toward her grand conclusion, which is number 8. She now puts in a new premise. It's proposition 4. She says some of the drunk drivers who act with malice aforethought, some of the people which proposition 3 says exist, some of them, she says, unlawfully kill human beings. So not all drunk drivers who act with malice aforethought end up killing someone, but some do. Right? That's her new premise. At least one drunk driver who acts with malice aforethought, meaning callous and wanton disregard for the consequences of his or her act for human life, at least one of them ends up killing someone. Now that's a factual claim, and I suppose someone could quibble with it, but I think it would be very easy to show that it's true. How do you show that a judgment of the form some S or P is true? It means at least one S is P. So all you have to do to prove the truth is to point out one example of something that's both an S and a P. Suppose I said some dogs have only 3 legs. What would it take to prove the truth of that? All I need to do is point to or find one dog that has 3 legs, and I'm sure there are some dogs who've been in an accident. I've seen dogs like that in my daily outings. I've seen 3-legged dogs, and they're hobbling along, but they seem otherwise happy and contented, even though they're missing a leg. So this proposition can be proved to be true just by finding one case of a drunk driver who acts with malice aforethought and ends up killing someone. Now, there's a new premise. Before we draw any further conclusions, let's look at proposition 5, a new premise. This one is also a legal definition. Murder consists in unlawfully killing a human being with malice aforethought. That's the legal definition of murder. So we can think of this as a conceptual claim. It's about the legal concept of murder and what it is or what it involves. This is not a factual claim. It doesn't say anything about how the world is. It's not like 3 and 4, both of which were factual claims. It's not a moral judgment. She's not saying anything about how wrong murder is or whether it's wrong or anything like that. It's just a legal definition. Why do we want to put legal definitions in here? So we're trying to make explicit all of the assumptions that are necessary to make the conclusion follow from the premises. So we need a couple of legal definitions along the way. Now, if you look at the argument, you'll see that a conclusion is now drawn from 3, 4, and 5. Remember, 3 was the first conclusion, but it has now become a premise of the second argument. So 3 combines with 4 and 5, which were new added premises, to produce 6. Here's what 6 says. Some drunk drivers commit murder. Where did that come from? Excuse me. It came from the fact that some drunk drivers act with malice aforethought. It came from the fact that some of the drunk drivers who act with malice aforethought unlawfully kill human beings. And it came from the legal definition of murder. Murder is the unlawful killing of a human being with malice aforethought. When you put those 3 together, you get 6. Some drunk drivers commit murder. Some drunk drivers are murderers. That follows logically from 3, 4, and 5. Now, is Steinbock done yet? Not quite. You may have noticed earlier on page 1, I said, the very first thing I said in my lecture notes is Steinbock's conclusion. She said, I will defend the proposition that a significant class of drunk drivers who cause death does indeed commit and often get away with murder. And that corresponds pretty closely to 6. So you might think when we get to 6, we're done. But we're not really done because Steinbock wants to say something about punishment. It's not enough just to classify certain drunk drivers as murderers. The question then arises, what should we do with them? And the rest of the argument, the third part of the argument, has to do with punishment. So let's take a look at it. Once we've gotten to 6, number 6 becomes a premise of the next argument. But we're going to need to add another premise. It's number 7. It's a moral claim, the first moral claim in this whole argument. The moral claim is that like cases should be treated alike. Notice the moral word should. That's what makes this a moral claim. What this says, it's a general moral principle that if you've got 2 or more cases that are alike in all morally relevant ways, then they should be treated alike. Suppose you've got 2 children. You should treat your children alike unless and until there's some morally relevant difference between them. And that might have something to do with their behavior. What if one of your children has been acting up lately or has violated one of your household rules, but the other one hasn't? The general presumption that you will treat your children alike is now rebutted. You may now punish the child who's acting up. So your treatment of your 2 children now differs, but that's permissible or justifiable because their behavior differs in a relevant way. But what if your 2 children behaved in morally similar ways? Neither one of them broke the rules, for example, or acted up. Then, because the 2 cases are alike, morally alike, the 2 children should be treated the same. That's what this principle says. Do you remember the debate in recent years about same-sex marriage? One of the arguments in favor of same-sex marriage, of allowing same-sex couples to marry, was that there's no morally relevant difference between same-sex couples and opposite-sex couples. So you've got same-sex couples here, opposite-sex couples here. The argument was that there's no morally relevant difference between them, and therefore they should be treated alike. Like cases should be treated alike. This principle goes back at least to Aristotle, the Greek philosopher in the ancient world. It's a very common principle. Most people understand it and think it's correct. And so Steinbock uses it in her argument. All right, what do you get when you put 6 together with 7? 6 says some drunk drivers are murderers. They commit murder. 7 says like cases should be treated alike. Therefore, 8, drunk drivers who commit murder should be prosecuted like other murderers. They should be treated like other murderers. And moving on now to page 3, drunk drivers who are duly convicted of murder should be punished like other murderers. So once we classify these drunk drivers, remember, only some of them are murderers, but once we classify them as murderers, we should punish them and treat them like the murderers they are. And that seems to me to be Steinbock's grand conclusion. We need to change the way we treat these murderous drunk drivers, the ones who kill, the ones who are depraved and reckless and end up killing someone. They're murderers, and we should treat them accordingly. Right? Don't give them a slap on the wrist and treat them as something other than murderers or something less than murderers. They are murderers. They are literally murderers in the eyes of the law. So we should treat them accordingly. And we're going to have to get used to that. Maybe we as a society have grown accustomed to slapping drunk drivers who kill on the wrist. We need to change our attitudes toward them. And one of the reasons I think Steinbock wrote this article is that she was enraged when she read about how certain drunk drivers got off or got a very light sentence, got a slap on the wrist. When you read things like this, your heart breaks. I have a hard time not crying when I read things like this. Look at page, where is it, 284. 284. She says, consider the case of William Rowan. Rowan was once sentenced to 45 days in jail, a mild penance for a California driving record that carried 6 convictions for drunk or reckless driving, 2 for hit and run. Last March, after leaving a downtown Santa Ana bar, Rowan drove onto a sidewalk, killing 4-year-old David Gunderman, who was waiting for the ice cream man. After hitting the child, Rowan slumped in his seat and lit a cigar. Police measured his blood alcohol content at 0.27. Now if that doesn't break your heart, I submit you're not functioning properly. It's heartbreaking. A 4-year-old boy innocently waiting for the ice cream truck. Not that that matters. He could have been doing anything at that moment, but it makes it more poignant. The poor kid, his life just starting, is killed by a drunk driver who may not have even known what he was doing. After the accident, he just stopped the car and lit a cigar, or was cigarette, whatever it was, lit a cigar. Okay, I suspect that Steinbock had read certain accounts like this and decided, I've got to do something. Right? I'm a citizen. This is outrageous, the way these killers are treated by the law. And when she began to look into it, she realized we don't need new laws. The laws that are already on the books cover this behavior. We just need to realize that and start punishing them as the murderers they are. She's not advocating the creation of a new crime. We've already got a second-degree murder crime on the books. And what these people, like Rowan, I think that was his name, what he is doing is he's murdering. He murdered that kid, right? Not in Steinbock's mind, not in some hypothetical world, in the actual world, under the actual laws of the state, he murdered Gunderson, the little 4-year-old kid. Why don't we treat him the way, as the murderer he is? Now, Steinbock could have done a number of things to change society and the way it views actions like this. She's a philosopher. She's a trained arguer. Think about that. Philosophers, as well as lawyers, are trained in argumentation. They know how to put an argument together. So I suspect that when Steinbock asked herself, what can I do to make the world a better place? She decided, I'm going to write an article and publish it in a prominent philosophical journal and hope that it gets publicized and hope that lots of people read it, are persuaded by it, and themselves go out into the world and try to change our attitudes toward these murderous drunk drivers. So Steinbock used her special skills to try to make a difference in the world. This is sometimes called applied philosophy or practical philosophy. It's philosophy with a purpose. It's philosophy used to make the world a better place. Okay, so this is a brilliant example of applied philosophy, and it happens to be beautifully written as well. Okay, now, if I had a board available, I would diagram the argument with little arrows and circled numerals, but I think you can figure out how to do that on your own. Now, this argument has 8 propositions in it, 1 through 8. If you are skeptical of Steinbock's conclusion, her grand conclusion, proposition 8, what can you do? What might you do? Well, as with any argument, you can challenge the truth of one or more premises. You can also challenge the validity of one or more inferences. So how many premises are there in this argument? Well, they are propositions 1, 2, 4, 5, and 7. You can see what I did in my notes. I used a blue marker. See it over here? I used a blue marker to highlight the premises. 5 of the 8 propositions that make up this argument chain are premises rather than conclusions. The other 3 propositions that make up this argument, those would be 3, 6, and 8, are conclusions that were derived from one or more of the premises. And keep in mind that some of these 8 propositions function both as premises and as conclusions. Which ones? Proposition 3. Proposition 3 was a conclusion relative to propositions 1 and 2, but it was a premise relative to proposition 6. You see what I'm saying? So if you are skeptical of the conclusion, or if you would like to resist accepting the conclusion of this argument, you have a burden to bear. Steinbock has taken pains to construct this argument. And by the way, this is Keith's reconstruction of Steinbock's argument. She did not lay it out formally like this. I did the same thing here that I did with Stephen Wise, and the same thing I did with some of the arguments in the Spelunker case. It's one of the things philosophers are trained to do. When you read an argumentative passage or hear an argumentative passage, you can try to figure out exactly what the argument is. And once you get it sorted out and stated correctly, you can then turn to criticizing it. So this is my reconstruction of Steinbock's argument. Suppose I then set out to find fault with it. What can I do? I could claim that the first premise is false, proposition 1. Now that's going to be hard to do because that's a legal definition. It's possible that the definition is incorrect, but that's really all you can do is say, this is not the correct legal definition of malice aforethought, or even part of the correct definition. Premise or proposition 2 is a factual claim. To challenge that, you would have to show that Steinbock's facts are incorrect, and so on. So there are 5 premises in this argument. Any one of the 5 could, for all we know, be false, and that would show that the argument is unsound, that it does not establish its grand conclusion. How many inferences are there in this argument? There are 3, as I said earlier. You can tell what they are by the word therefore, which appears 3 times. Sometimes people draw inferences thinking that they are valid when in fact they're invalid. So when I reconstructed this argument, I took great care to make the inferences valid. And it seems to me that they are valid. So you're going to be hard-pressed to challenge any of those three inferences. And that's because I put so much care in constructing them. So really, if I'm right about that, really the only way to challenge Steinbock's argument is by finding fault with one of the 5 premises. And I'll leave it to you to try to do that. Later on the third day of our discussion of Steinbock's argument, I will suggest some problems with her argument. Okay, let's turn now to the concept of murder. What is murder in the eyes of the law? Now, some people use the word murder in a moral sense. They say that, for example, killing a fetus is murder. The law doesn't see it that way. Legally speaking, abortion is not murder. Maybe it should be, but it's not. Some people would say, therefore, that while abortion, or perhaps late-stage abortion, is morally speaking murder, unfortunately, it's not legally speaking murder. The law needs to be changed so that it treats late-stage abortion as murder. And that would bring law into conformity with morality. Okay? There are people who argue like that. Law should reflect morality. Late-stage abortion, at least late-stage abortion, maybe others as well, is murder, morally speaking. Therefore, the law should treat it and punish it as murder. So you can imagine an article like this one with the title Abortion, in which the author does something similar to what Steinbock is doing. The author might argue that murder in the law is such and such, and that at least some abortions satisfy that definition. Therefore, these abortions that satisfy that definition are literally murders under the law. And then you would have a premise like 7, like cases should be treated alike. And then your grand conclusion would be abortion in these specified circumstances should be punished like the murder that it is. Okay, you can imagine an argument just like this drunk driving argument, but dealing with abortion instead. So at this point, if you have not yet printed out my handout called A Taxonomy of Homicide, you may want to pause the video and go do that. And then, first of all, take a look at the handout, get a good look at it, grasp its central features, and then as I go along, you can follow what I'm saying on that taxonomy. Okay, so let's get started. At some point, I'm going to pause and read that long first footnote, but not quite yet. All right, here's what I say in my notes. To understand Steinbock's argument, we must understand the concept of murder, and specifically second-degree murder. So what is murder? And once we get an answer to that, what distinguishes second-degree murder from, say, first-degree murder? Let's begin our discussion with a different concept, and eventually we'll come back to murder. Let's begin with homicide. What's homicide? You've heard the word. Some people contrast homicide with suicide. Suicide, the suffix side, C-I-D-E, means killing of. And S-U-I means self. So suicide literally is the killing of oneself. Homicide, the H-O-M part, H-O-M-I, refers to humanity. The French word for man is H-O-M-M-E. So homicide is literally the killing of a human being. Notice that says nothing whatsoever about the motive for the killing. Was the motive greed, anger, resentment, conquest? What was the motive? It doesn't say anything at all about why the person was killed. Nor does it say anything about justification, whether the killing was justified or permissible or defensible. So the term homicide is just a descriptive term. It applies whenever one human being kills another. So here's the formal legal definition of the term homicide. It's from Black's Law Dictionary, which is probably the best law dictionary available. Homicide is, quote, the killing of one human being by the act, procurement, or omission of another. So there are three ways to commit homicide: by acting, shooting someone, for example, or stabbing; by procurement. I can kill someone by seeing to it that someone else kills that person. A contract killing, let's say. And third, in some cases, we consider it homicide if I am in a position to save someone's life and I choose not to. I've killed by omission. I have allowed someone to die in a way where I had a duty to keep that person alive. If you're a lifeguard, for example, and it's part of your job description to rescue people who are drowning, if one day someone is drowning and you believe it, you see it, you observe it, and you do nothing, you choose to do nothing, you can be said to have committed a homicide. It's because it's part of your job description. It's part of your duty under the law. So that would be a homicide by omission rather than commission or acting. Now, once again, there's no mention in this definition of homicide of the motive for it or the justification for it. I put in a list of other sides just for your information. I'm sure there are many others. Infanticide is the killing of an infant. Genocide is the killing of a kind. Gen is the root of the word general, like a genus, a general class of something. So suppose you set out to kill, this may be a terrible example, suppose you set out to kill everyone who wears a certain style of hair, who has a certain hairstyle. You're killing a whole class, trying to kill a whole class of people for whatever reason. That's genocide. You pick out a class of people based upon some characteristic that the members of that class have in common, and you set out to kill all of them. Genocide. Regicide is the killing of a king or queen. Patricide is the killing of a parent, a father specifically. Matricide is killing of the mother. Parricide is the killing of a parent in general or a near relative. I mentioned suicide. Fratricide is the killing of a brother. Insecticide, killing of an insect. Pesticide, herbicide. Germicide, fungicide. Deicide, killing of God or a deity. Tyrannicide, killing of a tyrant. Bactericide, and I don't like this one, philosophicide, killing of a philosopher. We don't want any of that, do we? Although I'm sure it's happened. Okay, so now that we have this general concept of homicide, you can see it on my taxonomy, it's at the very top, right? It's a generic term meaning the killing of a human being by another. Let's focus on killing rather than procuring or omitting to save. Let's just simplify it by talking about killing. Did you know that not all homicides are criminal? Not all homicides are unlawful. Some are not. So if you go down one level in the taxonomy, I'm sorry I didn't bring mine up here upstairs, and I don't want to run down and get it, but I remember the basic features of it. Underneath the row where I wrote the word homicide, you'll see something like criminal and non-criminal. It's a basic distinction. Some homicides are criminal or unlawful, some are not. So what's the difference? Well, here are some examples of non-criminal homicide. These are killings that are not against the law. Self-defense. Certain acts of self-defense in which you kill the attacker are considered non-criminal. Yes, you've killed someone. It's a homicide, but it's not against the law because you were defending yourself. Secondly, execution of a judicial sentence. What if someone is duly convicted of murder or multiple murder and is sentenced to die and is put to death by the state. That's homicide. The state is putting to death a human being, but it's considered justifiable, it's considered legal, it's considered non-criminal. Third, some states allow the killing by a police officer of an escaping felon. So someone's escaped from prison, a felon has escaped from prison and is in the process of fleeing. A police officer who is observing this flight and who knows that the person in question is an escaped felon may shoot to kill, or at least to disable. But if you shoot to disable and you end up killing, which could happen, that's a homicide. You have killed a human being, but you would probably be exonerated. Your killing would be considered justifiable, non-criminal. And finally, another common version of non-criminal homicide is killing combatants in a just war. If you are in a war and you're on a war that's just and you're on the side that is in the right, you may kill combatants. And if you do, you've committed homicide, but it will not be criminal. It will not be a war crime or a crime in your whatever jurisdiction you're in, whatever country you're in. Okay, now there are a lot of special rules about this. I'm glossing over a lot of details. There are lots of limits on whom you may kill, but you cannot kill non-combatants. That would be a crime. If you kill someone who is not resisting, someone who's not in uniform, a child, for example, an elderly person, you would be no better than an everyday criminal, a murderer. Okay, so now that we've distinguished between criminal homicide and non-criminal homicide, let's focus on the criminal side of that line. Okay, do you see where that is in the taxonomy? Criminal homicide is either murder or manslaughter. There are just two possibilities. If you unlawfully kill a human being, you've either murdered him or her, or you've committed manslaughter. And you'll see that we're going to break those categories down even further. So what's the difference? And I'm going to be talking now about what's called the common law. Common law is judge-made law. It's not the law enacted by a legislature in the form of a statute. Okay, so we've got a huge body of law going back many decades, in fact centuries, that has been built up by judges. And that's called the common law. And there was in the common law a crime known as murder. Well, what was the definition? What is the common law definition of murder? Well, here it is. This is from Black's Law Dictionary. You ready? It's at the very bottom of page 3 of my lecture notes. Murder in the common law is, quote, the unlawful killing, right? That puts it on the left side of our diagram, the unlawful side. It's the unlawful killing of a human being by another with malice aforethought. And that malice aforethought could be either express or implied. And I'm going to talk about that distinction in a few minutes, but let's focus right now on the concept of malice aforethought. Let's look at the first footnote in my lecture notes. I'm going to quote from two very famous law professors who have literally written the book on criminal law. This is from their book entitled Substantive Criminal Law. It was published in 1986, and there may have been subsequent editions. I happen to own this 2-volume set, so it was convenient for me, but it may still be in print in a much later edition. But here's what Lefebvre and Scott say about murder. Murder is a common law crime whose complete development required several centuries. Though murder is frequently defined as the unlawful killing of another living human being with malice aforethought, in modern times, the latter phrase does not even approximate its literal meaning. What phrase are they talking about? Malice aforethought. What they're telling you so far is that be very careful when you see that phrase, malice aforethought. It probably doesn't mean in the law what you think it means. Here's what it means. They say, well, they're going to tell us in a moment. Hence, it is preferable not to rely upon that misleading expression for an understanding of murder, but rather to consider the various types of murder, typed according to the mental element, which the common law came to recognize and which exist today in most jurisdictions. And here they are. There's, first of all, intent to kill murder. So one form of malice aforethought is where you intend to kill somebody and do. Okay? You form an intention in your mind, I'm going to kill so-and-so, and then you proceed to do it, to carry it out. You carry out or execute your intention to kill. Okay, secondly, and by the way, that's typically called first-degree murder. All right, first-degree murder is the intent to kill type, where it's premeditated, you think it through beforehand, and then you form an intention, and then you act upon it and carry it out. Secondly, there is intent to do serious bodily injury murder. So it's an intentional act when you fall into this category. You intend to do something, but you do not intend to kill. Your intention is to do serious bodily injury, but as a matter of fact, you end up killing. What if I intend to disable someone? I'm aiming my gun, my rifle, and I'm trying to shoot the person in the leg. I have no intention to kill that person, but for whatever reason, I want that person disabled or stopped. What if my aim is bad, the bullet hits the person in question in a different place than the leg, and the person dies? I've killed, even though it wasn't my intention to kill. I did have an intention. It was to do serious bodily injury. Most states treat that as second-degree murder, not first-degree murder. All right, here's the next category, depraved heart murder. And I'm going to give you a definition of that in just a moment. It's a killing, not intentional. I had no intention to kill, once again, but my heart was depraved at the time I acted. I was reckless. I showed extreme indifference to the value of human life, and my action ended up killing someone. It won't surprise you that that's where Steinbock puts these drunk drivers who end up killing. And that's second-degree murder. Finally, there is a thing in the law called felony murder. And I'll give you the formal definition of that when we turn the page. Felony murder is murder. It's second-degree murder, but there's no intent to kill. There's an intention to commit some felony other than murder, but during the course of that felony, you end up killing someone. And here's how the authors finish up this paragraph. A comparatively modern statutory innovation divides murder into degrees of murder for purposes of awarding punishment. And I've been talking about first-degree murder and second-degree murder. You can see on my taxonomy, first-degree murder has a category of its own. It's reserved for those cases of intent to kill that are premeditated. Then, under second-degree murder, you'll see that there are three sub-varieties. There's the intent to do serious bodily injury variety, there's the depraved heart variety, and there's the felony murder variety. So let's turn to page 4 and take a look. All right, we need to start winding down. I should stop this lecture in about 5 minutes, and wherever we leave off, I'll pick up on the next lecture next week. Even if I don't get as far as I'd hoped to, that's fine. Now, I mentioned earlier, there's a difference between express and implied. Right? Malice aforethought can be express or explicit in your behavior, or it could be implied or implicit in your behavior. The word express covers cases in which there's premeditated intent to kill. That would be the category of first-degree murder that I just mentioned. And here are some examples. Suppose you formulate a plan to kill someone by poisoning. You acquire the poison, maybe you test it out to see whether it's effective at whatever dose. And once you decide what the proper dose is, you find a way to slip it into someone's food or drink. And if the person in question consumes that food or liquid and dies, you have committed first-degree murder, which is malice aforethought that is express. Now, you have premeditation. Notice, premeditate means meditate or think through. Pre means beforehand. So premeditated murder means you formulate the plan to kill well in advance of the actual killing. It wasn't spontaneous. You didn't formulate the plan instantaneously shortly before you killed. You planned it out, maybe for days or weeks ahead of time. Let's call that premeditation. And it's not the same as intent. You can form an intention to act instantly. Right? I can intend to kill someone right now and then carry it out. That's an intentional act, but there's no premeditation. Okay? I didn't premeditate it. There was no period of time where I thought it through and planned it. But it wasn't an accident either. I intended to do it. Another one is lying in wait, an ambush situation where you planned it out, you waited until someone came along, and then you did something to cause that person's death. So the term express in the phrase malice aforethought, comma, express or implied means premeditated intent. The term implied means that there was no premeditation and no intent either. There was no premeditated intent to kill. And there are three types of implied malice aforethought. Here they are. This is from my page 4. Killing someone during commission of a felony. That's the one that I called felony murder. What if your intent is to rob a bank? You take a rifle or a handgun into a bank with or without accomplices. You go into a bank with your firearm, intending only to rob the bank. You certainly have no intention to kill anyone, and therefore no premeditated intent to kill. You go in, the robbery goes awry, an alarm goes off, people start running, maybe out of nervousness you end up, your gun goes off, and one of the bank tellers or another customer, I should say a customer because you're not literally a customer, someone in the bank is killed. That's called felony murder. You've killed someone, you've not only committed a homicide, you've committed a murder, but it's not premeditated intent to kill. Right? You committed the murder in the course of committing some other felony. Now, the law punishes that quite severely, but not as severely as if you had committed first-degree murder. If you're wondering what a felony is, look at footnote 2. Common law felonies include all of the following: murder, rape, larceny, or what's often called theft, burglary. Burglary is not theft in the common law. I should point that out. In the common law, burglary has nothing to do with larceny or theft, even though people tend to think that. A burglar is someone who intends to go into a dwelling place in the nighttime with the specific intent to commit some felony therein. And it could be any felony. If you enter a dwelling place in the nighttime to commit rape or murder or kidnapping, that would suffice to make it a burglary. So the best synonym for burglary is not theft, but home invasion. You're invading someone's home at a time when there may be people there, and your intention when you enter the home is to commit a felony of some sort, maybe arson. Here are some other felonies: burglary, arson, kidnapping, robbery, manslaughter, sodomy, mayhem, bigamy, treason, and aggravated battery. In Texas, you may not know this, a third drunk driving offense is a felony. Now, I'm not suggesting that that's got anything to do with entering a home. What I'm saying is, if you're convicted a third time in Texas for drunk driving, you are a felon. You're no longer a misdemeanant. You're a felon. And that means if on your third drunk driving, you end up killing someone, you have committed felony murder, right? It's felony because it's your third conviction for drunk driving. And since you killed someone, you fall under the heading of felony murderer. And that's pretty severe punishment. The second type of implied malice aforethought is what we called earlier depraved heart murder. Here's what that involves. It's killing while acting in an extremely negligent or reckless way while creating a very high degree of risk of death or serious bodily injury to another. It's as though your heart is depraved. A normal person would not do what you're about to do in that situation because most people are concerned about other human beings. Here are some examples. Some of them are real, some are made up. Here's one made up. What if I live in a suburban neighborhood where there are wooden fences dividing the houses and their yards? I used to live in a place like that. In fact, I still do. I have a wooden fence and partly a metal fence. What if I buy a high-powered rifle and I set up some bales of hay or straw against one of the wooden fences in my backyard, and I put a target on it, and I set out to conduct target practice with my new rifle? Now, I may well never harm anybody with that rifle, but that would be only a matter of luck, good luck for me, because it's a very, very dangerous activity, as you can imagine. The bullets of this rifle can easily go through the straw, through the fence, and into the neighboring area where there may be passengers of cars going through the alley, or people walking, or it could go into the house next door. So even if I never end up harming anyone, still my behavior is reckless. It's extremely negligent. It shows a depraved heart. Only a person with a depraved heart could shoot a high-powered rifle in a suburban area like that. No intent to kill. But if you do kill, you fall into this category of depraved heart murder. Another example, this is a real example. I was in some city, workers were building a high-rise building, and they were many floors up into the air, let's say 10 floors. One of the workers kicked a pail off the roof. The pail fell 10 stories, struck a pedestrian walking on the sidewalk below, and killed the pedestrian. That worker had no intent to kill anyone, and yet the act of kicking the pail off the roof as a lark showed a depraved heart, and that person could therefore be charged with and convicted of and punished for committing depraved heart murder, which is a form of second-degree murder. Finally, there's the intent to do serious bodily injury murder, which is killing with intent to do serious bodily injury short of death. So there's, again, as I said earlier, there's an intention, but the intention is not to kill, it's to seriously injure somebody. Okay, we're almost done. Modern statutes divide murder into degrees. The common law did not. The common law treated them all as murder. Modern statutes divide murder into degrees. For example, intent to kill with premeditation, or what we might call premeditated intent to kill, is first-degree murder. All others are second-degree murder. And note, finally, when Steinbock refers to second-degree murder, she's talking about one of the three types. She's not talking about felony murder. She's not talking about intent to do serious bodily injury murder. She's talking about depraved heart murder. So we've isolated her claim. Steinbock's claim in this article is that certain drunk drivers who end up killing while drunk driving are second-degree murderers and therefore should be punished as second-degree murderers. Okay, I was going to try to get into page 5, but we made good progress today. I'm going to pick up next week in our next lecture with manslaughter. And you can see where it is on my taxonomy, and we'll pick up with manslaughter on next week. I should get my lecture posted on Monday. Okay, again, tomorrow, Tuesday, I will be in the classroom. If you show up, you can either ask me questions about the course or we can have a brief discussion. Attendance is optional, not mandatory. What that means is that anything that I say in there, well, I need to be careful here. If I say something in class that pertains to the article or to my lecture notes, of course I can test you on that. But if during our discussion we talk about other things, maybe we talk about social policy generally or drunk driving generally, of course, that won't be tested on the exam. So if you choose not to come to class, you'll be in good shape on the exam because the questions will be drawn from the reading and my lecture notes, plus any articles that I post on Canvas, unless it says optional reading. If it says optional reading, obviously I won't test you on that. Okay, we're an hour and 21 minutes in. My voice is about shot. Have a great day. Have a nice weekend. No exams coming up in the near future, at least in my class. So look for this lecture later today. I'll send you an email. And keep checking Canvas over the weekend because I'm going to put up probably one item each day over the weekend on the topic of drunk driving. Some of them you'll find very interesting, I think. Okay, have a great day. See you next week.